The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 3 cases that will be submitted. Those cases are in the matter of property seized from Jean Carlos Herrera and Fernando Rodriguez. Second case is Michelle Skadberg versus Gary Gately and Whitfield and Eddy. And the final case is State of Iowa versus Brett Calvin Hensley. The last case is now submitted to the court without an oral argument, and will proceed to hear the arguments in the seized property matter. Mr. Stowers.
May it please the court, I'm Dean Stowers. I represent the 2 claimants in this case, one of whom, Herrera, is primarily who we're here to talk about today, Mr. Herrera. This is a forfeiture case brought under Chapter 809A by the Waterman County Attorney's Office, seeking to forfeit a vehicle and its contents, the vehicle having been stopped on the interstate under circumstances that we contended violated the Iowa and federal search and seizure restrictions on vehicle stops. But we never really actually got all the way to that issue because of the way the court in Waterman County disposed of the case. Mr. Herrera filed a timely claim, asserted that he was an owner and interest holder in the contents of the vehicle, and Mr. Rodriguez asserted a claim asserting, of course, that he was the owner of the vehicle, which eventually, after a long drawn-out period of time, was returned to him by the state. So that issue was somewhat resolved, except for the attorney fee claim relating to the fees incurred in connection with securing the return of the vehicle, which the state objected to for many months. But in any event, we're here primarily on behalf of Mr. Herrera, and the question really is, what is the procedure a trial court is to follow when presented with a motion to suppress evidence in a forfeiture case at the time that the answer is filed or before. And in this case, the court received a motion to suppress. The motion to suppress was set for hearing. There was no forfeiture hearing then scheduled on the merits. And we appeared for the forfeiture hearing. Upon appearing for the forfeiture hearing, the state verbally, orally raised the question of whether or not the answer, which asserted that Mr. Herrera was the owner of the contents of the vehicle, could in fact be heard even on the motion to suppress or anything else in connection with the case. That issue was tabled at the point in time because we were all there. I had traveled over from Des Moines to be heard at the suppression hearing. We went ahead and did the motion to suppress, completed the record on it after a brief oral argument at the beginning on that issue. And then the court indicated that it wanted the parties to brief the issues raised by the state in their oral motion or oral request, and the defendant to do the same, or the claimant, in this case Mr. Herrera, to do the same. We did that after the hearing, suggesting that those issues regarding additional information that the state believed was required for Mr. Herrera to be heard were ones that could be addressed following a ruling on the motion to suppress, and that was the appropriate manner to do it, because otherwise you'd be compelling somebody, for example, to specify or answer essentially interrogatories or questions about the source of the property, how they acquired ownership of it, potentially.
Counsel, it's not really interrogatories. It's laid out in the statute that requires the claimant to plead things such as the date and identity of the transferor, that is, who he got the money from, and the circumstances of his acquisition of interest in this $44,000.
Right.
There's federal authority supporting the proposition that you can dismiss these claims on the pleading when the person alleging an interest in the cash doesn't provide the information. Why shouldn't we follow those cases?
Well, there's actually federal cases that say the opposite thing. And we cited a whole line of those in our reply brief, which I invite you to review. They actually say that the threshold issue, at least to get you into court as a claimant federally, is that you have to assert you're an owner or a interest holder in the property. Once you've done that, which is what they said, what this court said in Aronson, then you're in. You're a claimant as defined by this statute in 809A. So once you're a claimant, you get to be heard on your claim as an owner or interest holder. And then these sort of, I would call them evidentiary details, become issues for the hearing and the merits. Because ultimately the issue in a forfeiture case isn't really the sufficiency of the answer. The issue is whether or not the state has a right to forfeit your property.
Yeah. And the district court didn't decide whether the searches were constitutional, didn't get that
Right.
far. But you did
Right.
have an evidentiary hearing on the motion to suppress. So,
Yeah.
So if we agree that that should have been decided first, should we decide it now or remand it for the district court to have first crack?
I think the appropriate thing probably is to remand and have it decided by the trial court, since we don't have a decision and findings of fact on those things. I think that's probably the better procedure. I mean, I think under the Part D case and other cases, this case kind of just follows down the lines factually, and I think the issues are fairly foregone.
But you know, in Part E, it's a little bit different. There, we concluded that the trooper hadn't developed enough grounds to continue to prolong the search. And here, it seems like it's hard to contest the stop when the driver's speeding, although I spent a lot of time on Interstate 80 and a lot of people going over 73 miles an hour without getting stopped. But do you concede that the stop itself was constitutional?
Well, there's a problem with the stop because the person that did the stop was a DOT traffic enforcement, I guess I'd call it commercial vehicle enforcement officer. And there's been a line of cases that maybe haven't reached the Iowa Supreme Court yet, or maybe it's submitted and I don't know it. Maybe I should, but there's some authority that suggests that this officer who did the stop itself did not even have authority to stop the vehicle.
And that hasn't come to us yet, but wasn't there a legislative enactment that granted that authority to the IDOT for a year, and did this case fall within that period?
I don't want to say one way or the other. I don't believe that it did. But getting back to your question about these source of the funds and this sort of thing, if the procedure that the Court of Appeals seems to have suggested is the procedure for one to follow, that is, you have to go ahead and tell them everything, even though you're still contesting the legality of their seizure of your property, then what they're really saying is you have to do that first, even if it's fruit of the poisonous tree, that is the original search and seizure and detention and impoundment of your property. And all the case law says, and the Court of Appeals sort of got to that conclusion through an erroneous rationale, and their rationale was, it wouldn't be fruit because it doesn't have anything to do with the stop itself. It's just you're having to make a claim to contest the forfeiture of the property they seized in the stop. And I think we went through in our further review petition and explained why the Court of Appeals was wrong about that.
One of the things that surprised me a little bit about the briefs, and I'll give you an opportunity to correct the observation if I'm wrong, but I didn't see a lot of current authority. The Wallstrom case is 1993. I saw some circuit cases, a smattering of circuit cases, but they're kind of dated too. surprised me a little bit, because I would have thought that civil forfeiture seems to be kind of a hot topic, but
You would think.
I didn't find any current federal case law. Now, you want to correct me on that if I missed something? I mean,
I don't think that there's, the federal case law is a little bit different because there are some particular procedures under the admiralty rules, which are the rule. I mean, this is so archaic
separate
stuff.
statutes and so forth.
Yeah,
but I didn't find persuasive federal authority in the last 10 years kind of going over in detail some of your claims. Have I missed it? I'm going to ask the same question of the state, because I didn't find much current authority.
Right, that's because the authority, it goes all the way back to the 1800s in Boyd, because in the Boyd case, the United States Supreme Court said, you can't even rely on illegally obtained evidence to establish probable cause to forfeit property.
Let me tell you, let me be more specific where I'm coming from. I mean, it looks to me like you're making a Fourth Amendment claim. I'm not sure you made an Iowa constitutional claim below, or you
We
make-
did.
Did you make an Iowa constitutional claim here? I don't know. But for now, I'm looking at federal authority, if you don't mind. And we've come a long way from Boyd. I mean, some of us haven't liked it much, but I mean, Boyd has been modified. I'm trying to get a sense of what the current United States Supreme Court would do, and I'm not sure I got a lot of education on it. So help me.
Well, here's the way I kind of think of it. There's a right somebody has to be free from an unconstitutional search and seizure, particularly in the case where there's not been a prior judicial process, such as a search warrant. So there's been no judicial involvement. They seize your property. In those cases, we all know the burden's on the state to establish that they have acquired and seized your property illegally, or legally, I'm sorry, through a lawful process that accepts it from the warrant requirement. And ultimately, in those cases, the state has to show, among other things, probable cause for the seizure. And the United States Supreme Court in the Boyd case and in one Plymouth sedan, et cetera, they've held that the exclusionary remedy for Fourth Amendment violations applies in these cases. They've also held that you can't even rely on probable cause. You can't even rely on illegally obtained evidence to establish probable cause. Ultimately, in this case, if this thing goes back, even on the current situation, and you say, hey, you didn't have a right to make the motion now, I'm going to tell you, I'm going to go back over to Pottawatomie County and contest their right to be able to forfeit this property, because I'm going to say, under the Iowa Code, they have to establish probable cause to forfeit it at this point, just as the Iowa Court of Appeals said. Now, when they go to establish probable cause to forfeit it, this very issue comes right back to the surface, because the United States Supreme Court says you can't rely on illegally obtained evidence to establish probable cause to forfeit. And the only person that has the right to contest that is the owner of the property, or the interest holder, and the person who had standing to object on the search and seizure that occurred. And that's my client. So we have to be able to be heard on this. It's absurd to think otherwise, because otherwise we're just going in a big circle. So I've had this come up in a number of these forfeiture cases, and the usual way that a court deals with it is like any other motion to suppress. You file it, you have a hearing on that, because everybody understands that's a pre-merits issue. You have a hearing on it, and you go ahead, and there's a resolution of it, which defines the scope of the evidence that may be used to seek to forfeit the property.
No, I want to get back to the Fifth Amendment issue, because I'm frankly more bothered by that. It does trouble me that you have this concept where there's, in order to file an answer, it's not like a normal civil answer where it's sufficient to just deny what the other side is alleging. You're, in effect, required to provide some information that may be incriminating. Now, the question I have is, if we agreed with that conclusion, that is, that didn't serve a legitimate, some other legitimate goal that the state has a legitimate interest in to acquire that information, other than potentially incriminating your clients, could we just sever 809A13(4)D, that piece that requires you, in order to, even step into court to provide the date, the identity of the transferor, and the circumstances of the claimant's acquisition of the interest in the property? Because it seems to me that that is what you're really objecting to, right? You're not objecting to being required to say, in fact, you did say that you have an interest in your clients have an interest in the property and what that interest is. Would that solve the problem if we just took D out of the statute and said you don't have to do that to file the answer?
I think you could. I don't know that you have to do that in this case, because we objected really solely on search and seizure grounds in our answer, and that's all we've done to date, is say that. And then we've said, well, if denied on that, then we would be in a position where we might have to elect whether or not to provide the information in D or not.
Here's
and if
my,
you
let
get
me
to
talk
that-
about the,
yeah.
let me tell you well, I'll ask you in rebuttal. Thanks.
Okay, I think I used all my time, however, but I'll ask for some for rebuttal, though. Thank you.
Thank you as well, Mr. Stowers. Ms. Chambers.
May it please the court. The real issue that Mr. Herrera is raising on appeal is whether he should be allowed to litigate his motion to suppress before establishing that he has an interest in the property at issue. That should not be allowed for many reasons. First of all, to allow someone to file a claim without establishing that they have an interest in the property means they can never prevail in that case. They can never get return of the property. Even if the search was illegal, even if the property is not forfeitable, it's not going back to that person unless that person shows an interest in the property that is recognized by the state.
Isn't it enough if it's currency, possession and dominion? I mean, I was reading through some of the cases that have been cited. The federal cases also seem to stand for the proposition that the initial showing does not have to be very much.
It doesn't have to be very much, but it has to be something.
Didn't he say, he said it was mine and he had possession and dominion over it?
The state really strongly contests that claim of possession. The cash that's forfeited is cash that was found in a secret compartment in the car that the police didn't find in their first search. At no point did either the driver or the passenger say, "Hey, there's some cash in that console. It's mine." And it's not clear that at all that they even knew that cash was there.
Question, Ms. Chambers. Suppose the legislature passed a statute that says if there's if the state seeks to forfeit a vehicle, in order to contest the forfeiture, the party that must file an answer, and in the answer they must give a detailed description of everywhere they've been for the last month and everyone they've had contact with. And would that be constitutional?
I assume not.
Now, how is D different? Why do you need to know the date, the identity of the transfer, the circumstance of the acquisition, the interest? Doesn't this seem like what is going on is they're trying to help the state prove its case?
No, but I think what's important to remember that this is not in personam forfeiture. This is in rem. So we have a piece of property. We don't know if it has any connection to anybody else who's making a claim. They have to establish that. We have to prove, the state has to prove that's fruit or instrumentality of a crime, or that it's.
In fact, it didn't have to prove here, right? And you're not
At least show
contesting now that at least what the Court of Appeals did is correct, right? That it has to go back. You at least have to show some
Right.
probable cause,
But
right?
to bring a petition, they have to show probable cause. So, but then that is, if we go after a person and then seize their property and forfeit it, so it's in personam, then that connection is implicit. But here we have an in rem, so the person who's claiming the property has to show an interest. So the reason the statute requires the claimant to say when they got it, who they got it from, the date, is to allow the court to make an initial determination that this is someone who has a reasonable chance of showing a recognizable interest in the property.
But can't you do that at the trial? I mean, of the forfeiture case? That's what I don't get. I mean, it's like any civil proceeding. People file an answer, and the answer is just the answer. It's just the allegation, and then you go in and have a trial. And if all the person says is, it's mine, I owned it, and they have no proof of that or where they got it from, then they'll probably lose in the forfeiture case. But why require that in order to get a foot in the door? That's what bothers me.
Because why would we litigate a motion to suppress? Why would we litigate a forfeiture hearing and then find out that the person has no chance of recovery? It's just a waste of resources. There's just that person cannot prevail ultimately if they don't provide that information. So let me also just, to the extent that the court's question sort of suggests the state is exploiting the answer to investigate their case, let me make clear that 809A provides the specific powers for the county attorney to investigate either before or after the filing of a petition. They can issue interrogatories, they can call in witnesses to give testimony. So there's no need, so the answer isn't something that the prosecutor is
Difference
focusing
there
on.
is when they do that, they're not potentially requiring people to give up their Fifth Amendment rights in order to just claim an interest in the property. That's the concern I have.
Well, I have two answers to that. First of all, that is not really the claim that the defendant is making, or that Mr. Herrera is making in this case. He's really saying, I wanted to litigate my Fourth Amendment interests.
Well,
And
what
that can
what
be-
he's saying is if he loses on the Fourth Amendment interest, then you don't have the clash of Fourth Amendment and Fifth Amendment interests, is what I hear him saying. So-
I heard him to say, my answers, the information I provided in the answer would be derivative of the Fourth Amendment violation that I'm alleging. And it wouldn't be. The information in the answer is not given in the course of the illegality. The information about when and how he obtained property existed before the search. It was provided after he had counsel and weeks had passed. So the claim that the information in the answer is derivative of the search just can't go anywhere.
Well, let me ask you this question then. So, suppose, and obviously hypothetical, but suppose you did the search and seizure first, and suppose further that
Did the search or did the motion to suppress? Sorry.
I'm sorry. Supposing you did the search and seizure question first.
Okay.
And I know that that's not what happened here, although you had a hearing. But supposing you decided it first, and let's just suppose you say the stop was bad. What happens in the forfeiture case then?
Maybe no effect at all, because it may be that search is completely unquestionably illegal, but it may have no effect in the forfeiture. So let me give you an example.
Oh, but
If the
wait a minute.
if the passenger were filing the claim for return of the property, even if that search were illegal, the passenger has no privacy interest in the car. So no matter how illegal the search, that would not affect the forfeiture as to the passenger. Also, even if the search is illegal, the property can still be forfeited. We just can't use evidence found in the search. So again, possibly no impact. If that information from the search is suppressed, the prosecutor can simply use its investigatory powers to go out and look for that evidence in another way and still proceed and meet its burden at the forfeiture hearing.
If we decide that the search, the motion to suppress should be decided ahead of the other issue, should we decide it or remand for the district court to take the first crack?
The district court should get the first crack at that.
Did the DOT officer have authority to pull over a motorist?
There is no binding authority that says a DOT officer cannot make a traffic stop. There are some district court cases that say that. At the time of, so there's no case law still saying that they can't do it. There's a question of whether the statute empowers it. The amendment to the statute, I think, took place after this stop. I didn't double check the dates because that issue isn't raised here. It's one of the reasons why this court shouldn't decide the suppression issue in the first instance. Those should be decided in the district court.
Why did the legislature provide citizens with a attorney fee recovery if they prevail? And does Mr. Rodriguez, does he qualify as a prevailing party?
Does Mr. Rodriguez, let me first say that they did not seek further review on that issue. But even if he did, in this case he did not, because he didn't prevail, the state gave up. They just said, okay, take it back.
Well, what's the purpose of allowing attorney's fees? Isn't it to motivate attorneys to take these cases? And if the government can give up right at the 11th hour after a lot of effort's been put into the case. Doesn't that defeat that purpose?
That might be an issue to be litigated in a different case, but in this case, the district court also found that even if attorney's fees were allowable, there was no showing that the attorney expended time on that particular defendant, that the attorney's fees were attributable to Mr. Herrera, not Mr. Rodriguez.
Couldn't we solve that by allowing a remand for him to segregate the time he spent just getting the car back for Mr. Rodriguez?
We typically don't allow a litigant to relitigate an issue that's been decided by the court, and not reversed by the Court of
Well,
Appeals and not
hypothetically,
sought further review on.
Let's say we follow the family law cases in Iowa that you can be a prevailing party upon your opponent's voluntary dismissal, or similar federal authority, although that's a mixed bag, and we reverse the trial court. Then we're confronted with, well, he didn't segregate the fees, and yet we can tell from the record he spent some time just for Mr. Rodriguez to get his car back. Wouldn't we have the authority or the power to if we reverse the district court ruling, said he is a prevailing party, to remand and allow the district court to determine the amount of attorney's fees?
I'm thinking. Well, again, he didn't seek further review on that. He lost it in the Court of Appeals, and he didn't seek further review. But could the court do that?
Once we grant
Yes.
further review,
Sure.
all issues raised in
Sure.
the appeal are fair game.
So sure, the court could do that.
I'm sorry.
I'll just say this, the state's primary concern in this case is not attorney's fees.
I want to invite you to respond to my kind of general authority question. You heard me ask Mr. Stowers about current authority, and from my perusing of the cases cited and so forth, a lot of it is older, frankly. I mean, 10 years, 15 years, 20 years. Have I missed something? Is there more current authority that I should be looking at, or?
There obviously are recent cases, but there's been no change in the law. There's been no trend in the case law. I suspect that the court is wondering, in light of, there's a lot of publicity about forfeiture, there's a lot of policy discussion about forfeiture, and that's true. There is a lot of policy discussion about forfeiture, and the legislature has actually made some changes to the forfeiture statutes in response to some public concerns. But none of that is constitutional law, and none of that is statutory law.
Is it really a Fifth Amendment violation to compel the pleading requirements if the claimant can choose just to give up his claim?
It isn't. The Fifth Amendment does not protect criminals from making difficult choices. We often require defendants to make, in criminal cases, to make those choices, and even outside the criminal prosecution. So, for example, someone who's engaged in illegal gambling has to decide, am I going to report my earnings and potentially incriminate myself on illegal gambling, or am I going to not report my earnings?
Doesn't the state,
face
like
tax evasion?
I wrote in the Webster County case which involved sort of that trade-off between the Fifth Amendment, that the state has to have some legitimate interest, some sort of separate legitimate interest it's pursuing. In that case, it was a penological interest in providing appropriate treatment to sex offenders. In the case you just mentioned, it's everybody should pay taxes on their earnings. I mean, that's a legitimate interest, separate and apart. Here, when you're asking for the date, the identity of the transfer, and the circumstances of the claimant's acquisition, it's hard for me to draw any conclusion other than the state is requiring the defendant or the claimant, I guess, to help prove up the state's case, and that's what troubles me.
I think, let me say why I disagree with that. So in an in rem forfeiture, the first thing is the state has to prove probable cause to believe that the property is forfeitable. And then a claimant has to come in and say, I have an interest in this property, and my property interest has to be taken into consideration here. So maybe the property is forfeitable, but I'm an innocent owner. Or maybe the property isn't forfeitable, and so I can get, either way that I could prevail. But if they don't show how they're connected to the property, they don't have, the outcome of the forfeiture doesn't have any impact on them. So if they can't show, if they can't show where and how and when they legitimately got the property, they can never prevail on getting the property returned to them. So whether they do that at the answer stage or whether they do that later, they must show that they have a legitimate, recognized interest in the property, or they can't get the property.
Well,
Even
but
if the property isn't forfeited,
if it's
not going to them.
if it's not forfeitable and they're the owner or the possessor, isn't that all they need to show?
If it's not forfeitable and they are, yes, but he hasn't shown that. He hasn't shown that he is the owner or possessor. And there is, he suggests that there's
He's
not.
claimed that. Isn't that enough to get into
He has,
court?
but so did Mr. Rodriguez. Mr. Herrera suggests that there's not competing interests here, but if you look at the answer filed, their joint answer, both of them claim an interest in the cash. And they don't explain what those interests are, so the district court has no way of saying, okay,
Isn't that something for trial? I mean, so fine, there's competing interests maybe, but there's not a, correct me if I'm wrong, but there's not a third claimant here, I take it.
Another reason for an answer is to allow the parties to prepare for the hearing. So if the state has no way of proving or disproving what someone's property interest is if they haven't identified what it is. So they kind of show up at the hearing and say, oh, by the way, I got this cash from my bank account in New York City. Well, how is the prosecutor going to meet that at the hearing? The way to do that would be to subpoena the bank records and determine whether, in fact, he did take a withdrawal from his account. You can't wait till the time of hearing to do that.
Thank you, Ms. Chambers.
Thank you.
Rebuttal, Mr. Stowers?
Thank you.
Could you begin by addressing, is Mr. Rodriguez claiming an ownership of the cash?
No. He was the title holder to the vehicle that Mr. Herrera was permissively driving. And to get to your question on fees, obviously, I expended time and effort on his behalf, and the court and the resistance to the fee claim in this case was that he's not a prevailing party because we gave up. So we defended, or we asserted the fee claim and made it based upon that position that they had taken. The court went ahead and agreed with that and then went on to say, oh, and I also find that he didn't spend any time whatsoever on his behalf. And obviously the pleadings and other information indicates otherwise. So I think that part of the ruling is wrong and should be remanded.
Now, let me ask you about your Fourth Amendment issue. And I recognize your argument is you should do the motion to suppress before you really require an answer on the merits.
Right.
But would it also be possible to follow this approach, which is you require the answer on the merits, then you have the suppression hearing. If the motion to suppress is granted, then it all goes away, including information in the answer that was derived from or related to the illegal search.
Well, the problem with that, it seems to me, is that what you're actually doing at that point is you're compelling somebody to provide information that, if their motion to suppress is meritorious, has been derived from an illegal search and seizure, and you're compelling that first prior to giving them the remedy. Now, we don't know what happens with that information once it's provided, but it goes out into a public pleading and is then used for whatever purposes law enforcement chooses to use it for. That doesn't mean they can't go out, follow up on it, pursue other people, et cetera. And that sort of thing is what the protection of the Fourth Amendment and the corresponding provision of the Iowa Constitution are designed to safeguard against.
I mean, I think Ms. Chambers raises a valid point that in a motion to suppress, often the defendant is forced to provide information in order to prevail at the hearing that the defendant would not otherwise would otherwise prefer not to provide.
Yeah.
And then it's kind of a trade-off. If you win the motion to suppress, then sometimes that information can't be used.
And under the Simmons case from the United States Supreme Court, they've said that any testimony a claimant has to give at a suppression hearing in order to establish standing. This is when they did away with the automatic standing rule. In Simmons versus United States, the United States Supreme Court said that testimony is immunized. You can't use it at all.
And why doesn't that principle protect you here?
Because it's not the law at this point. We'd have to make it the law, I guess, in order to do that. You'd have to say, well, your answer is immunized as a declaration from the Iowa Supreme Court, and therefore then you can say whatever you want in your answer and go ahead and have your motion and your defense or your forfeiture, I guess. I think that this all comes up in the context of a motion to suppress due to an illegal search and seizure, where somebody is required to come forward to make certain statements to get legal standing. And in this case, the only standing we need is that of a claimant, and we have that. Aronson said that. Every other case said that. The statute says if you're an owner or interest holder, you're a claimant. And yet, when we made our answer, we were told we can't be heard. The simple remedy is to simply just say, hear the motion to suppress first, make a decision on that. That's the procedure in every other kind of case. I don't know why we need to make up a new set of rules for forfeiture cases, which are quasi-criminal, and have that hearing first. Get the ruling, and that will dictate what follows, because at that point we can say, if we prevail, that the information they want would be subject to exclusion at the hearing anyway, so they aren't going to be able to have access to the information under D anyway, because it's been obtained and derived from an illegal search, seizure, and detention of property, so it's out. If we lose the motion, then we get to elect, as we always would, to assert our Fifth Amendment privilege. Then you might have another issue, which is then they're going to go in there and say, well, you asserted your Fifth Amendment privilege to the information in D, and therefore you're out, okay? Then you get into the case law that deals with an automatic penalty for asserting silence. And that case law, I think, would say that you can't really forfeit property because somebody who says they're an owner or interest holder but refuses to answer further questions is somehow in default of the answer requirements. I think they still have to go in and prove up their forfeiture. And they're going to have to do it anyway under any circumstance based on legally obtained evidence. And that's all we've ever said. So I've gone over my time, so I apologize, but thank you for the extra time. Thank you.
Counsel, thank you as well. Ms. Chambers, thank you again. The case of in the matter of property seized from Herrera and Rodriguez is now then submitted. We'll next hear the arguments in Skadberg versus Gately.